Welcome everyone to Defend the Sacred Beyond the First Amendment, featuring Dr. Michael McNally. My name is Hans Gustafsson. I have the pleasure to serve as the director of the J. Phillips Center for Interreligious Studies here at the University of St. Thomas in Minnesota. We're so glad you're able to take some time with us today over the lunch hour, at least the lunch hour here in Minnesota, to be with us and to learn a little. We have a wonderful event planned for you. We'll aim to be done at 1:30 p.m. Central Standard Time. And before we get to introductions, I want to mention our outstanding collection of sponsors and collaborators in addition to the J. Phillips Center here at St. Thomas. This event is co-sponsored by the Terrence J. Murphy Institute at the University of St. Thomas, which is co-directed by Dr. Gregory Sisk and Dr. David Diebel, and the J. Phillips Center for Interfaith Learning at St. John's University, directed by Dr. John Merkel. Our collaborators include the Center for Engaged Religious Pluralism at St. Mary's College of California, directed by Dr. Barbara McGraw, the Center for the Study of Religion, Culture, and Society at Elon University, directed by Dr. Brian Pennington, the College of Arts and Sciences at the University of St. Thomas Solve Initiative, titled Cultivating an Educational and Institutional Relationship Between Dakota Communities and the University of St. Thomas, led by Dr. Mike Klein, and the Forum on Faith and Life at Concordia College in Moorhead, Minnesota, directed by Dr. Jacqueline Bussey. I also want to mention that programs like these are made possible in part with the generous support of the J. and Rose Phillips Family Foundation here in Minnesota. Today's presentation is based on a very recent book published by Dr. Michael McNally with Princeton University Press, which all of you can purchase for 30% off with free shipping by using the special offer code, which you see on the screen in front of you, but is also on the event page. Now, in a moment, I will introduce our moderator. Please know that our chat function has been disabled, but I encourage you to submit questions using the Q&A function on the lower part of your screen during and after the presentation for Dr. Malley to consider. I will now introduce our moderator and pass it over to her. She will then introduce our speaker and moderate the Q&A question. I'm pleased to introduce Dr. Barbara McGraw. She's the director of the Center for Engaged Religious Pluralism in the School of Liberal Arts and professor of social ethics, law, and public life in the School of Economics and Business Administration, both at St. Mary's College of California. Her areas of expertise include religion and the law, public policy and social issues, religious pluralism in American public life, religion in prison, and cross-cultural interfaith leadership. Prior to earning a doctorate in religion and social ethics from the University of Southern California and becoming an academic, Barbara was an attorney for the prestigious international law firm Skadden Arps in California. Now, Barbara, we're honored to have you involved. Please take it away.
Thank you very much, Hans. It's my pleasure to introduce Michael McNally. He is the John M. and Elizabeth W. Musser Professor of Religious Studies at Carleton College. His first two books, Ojibwe Singers, Hymns, Grief, and a Native Culture in Motion, and Honoring Elders, Aging, Authority, and Ojibwe Religions, were rooted in community relationships at Minnesota's White Earth Nation. A Mellon New Directions Fellowship enabled him to gain targeted legal studies training in the various fields of law where Native sacred claims are brought, including courses at the University of Minnesota Law School and with leading law school scholars all around the country. That work produced 2 law-reviewed articles in the Journal of Law and Religion and in the BYU Law Review. The prestigious Guggenheim Fellowship was awarded to him in 2017-18, and it enabled him to complete the book about which we'll hear soon, Defend the Sacred, Native American Religious Freedom Beyond the First Amendment, published this April, as Hans said, by the prestigious Princeton University Press. Dr. McNally is a very highly regarded, well-known scholar nationally on Native American religion and religious liberty accommodation, and we are extremely fortunate to have him here with us today. Dr. McNally.
Thank you, Barbara, for that warm introduction. I have such great admiration for your work, the American Academy of Religion, and on religious freedom, especially religious freedom in the American prison system. So it's an honor to be on the panel with you today. It's also an honor to be a guest of Hans Gustafsson, the J. Phillips Center, the Murphy Institute at St. Thomas Law School, and all the people that are helping to make this program possible. I'm especially honored and humbled that those of you who are joining us are able to take time out of your day in these extremely momentous and charged times when it seems like every hour counts. I hope I'm worthy of your time and worthy of the urgency of the concerns that Native peoples feel about the matters that I'll be speaking today. I first want to acknowledge that I am currently in Northfield, Minnesota, but those of us also in the Twin Cities are on the traditional homelands of the Metawakan Dakota people. And in my case, in Northfield, I'm on the treaty lands of the Treaty of 1851. Some of you in the cities are on the treaty lands of the Treaty of 1805. And if you want to know more about that, I invite you to go to treatiesmatter.org, a fantastic website that orients all of us in Minnesota to the way that we live and move and have our being on traditional homelands of Native peoples. So here we go. This year has witnessed the fifth big ruling in Standing Rock's litigation over the Dakota Access Pipeline and its crossing of the Missouri River through a sacred landscape a half-mile upstream from the reservation boundary. Only one of the four previous rulings had even remotely gone Standing Rock's way. But this past March, a federal judge in DC who had earlier rejected the tribe's efforts to stop construction called for a fuller environmental impact statement. In July, he ordered a halt to the flow of oil through the completed pipeline until this fuller review process had run its course. And this indeed was cause for celebration just a couple months ago until that order was overturned by an appeals court. And an even fuller environmental review is not at all certain to compel the US to permanently undo its approval of a pipeline that has, after all, been completely operational for well over 2 years now. In the court of public opinion, the whole country's imagination was captured with the resolve and urgency of the encampments and their rallying cry, "Defend the Sacred," from which my title comes in this image and before you. But the claims have had so little traction, meaningful traction anyway, in the courts of law. My book is about both sides of this story. I offer an account of Native religions, of resourceful efforts by Native peoples determined to defend the sacred in law, and how those efforts are in themselves generative of religion. I also offer an account of law, exploring why legal remedies seem to fail them so consistently, even in the land of religious freedom. Ultimately, I commend intellectual and legal developments that reimagine religious freedom in the collective shape of federal Indian law and international human rights law concerning indigenous rights. The project began 15 years ago in a class I was teaching on Native American sacred lands. I'm an American religious historian who's done field-based work with Minnesota's Anishinaabe people. But in this new course, I wanted students to encounter the vitality of religiosity that's tangible as today's Native peoples assert their rights, but also to ask why the courts have so consistently rejected what seemed to me a no-brainer, a religious freedom right to sacred land protection. The course took up the definitional question of religion raised by Native peoples, commonly asserting they have no word for religion, and tracked that definitional question into the law. In brief, Native religions are many, not one, often with widely divergent beliefs even in one community. They are decidedly oral. They are oriented toward sacred lands in ways that defy most Christian analogies. They're integrated with other less visibly religious aspects of their lifeways, where the sacred is not clearly set apart from the profane matters of economic livelihood, law, or political organization. Religious beliefs and practices are often strikingly local, not thought of as universal propositions disaggregated from everyday life on a particular landscape. No one tries to convert you to Ojibwe religion, for example. native religions have been forcibly interrupted, and though resurgent, renewed traditions these days can meet up with questions of their authenticity, as when Cherokees exiled from their homelands on the Trail of Tears failed to persuade a court of the continuity of their religious practices on ceremonial places in their original homelands. Most importantly here, native traditions are often about collective obligations and duties, elementally the province of communities rather than a matter of individual belief or conscience or subjective experience. As Vine Deloria Jr. famously put it, there is no salvation in tribal religions apart from the continuance of the tribe itself. As I became more conversant with the cases, I came to realize over several years two things law students learn in the first week. First, advocates make multiple arguments to advance their client's case, and my course's myopic focus on religious liberty meant that students were missing much of the case law action. As my subtitle suggests, beyond the First Amendment, Native nations hardly stopped with religious freedom law to protect what is sacred to them. I received 2 years support from the Mellon Foundation to gain targeted legal training in other legal fields in which sacred claims have been advanced: treaty-based federal Indian law, cultural resource law and environmental law, international human rights law, and Native-specific statutory law, especially the statute on repatriation. In fact, it was in the context of a reading course on the remarkable story of the passage of that repatriation law that I came to know the redoubtable Suzanne Harjo, the Cheyenne and Hodoggi Muskogee writer and advocate who came to Washington, D.C. in the Carter White House, and in the decades since has become among the most preeminent strategists toward Native religious and cultural freedoms. Suzanne's wisdom, her patience with me, and well, her impatience with me have made possible largely whatever I get right. I learned over time a second thing law students learn on day 2, a way of reading law not just for what's clear, but for what's ambiguous. Early on in this project, I'd come to the view that the problem of Native American religious freedom lay not simply in finding better metaphors to convey the religiousness of Native religions, that might help at the margins, but I was persuaded by a developing consensus among recent religious studies scholarship that the inclusive ideal of religious freedom is itself part of the problem, as it masks exclusions that are baked into the discourse itself. But the more I've learned to read and think like a lawyer, the more I've come to think that the indeterminacies of the category of religion, which are at root in many of these critiques of the discourse of religious freedom, that the indeterminacies of religion, the play and meanings that can happen with it, are an opportunity, not just a limit, on the possibilities of religious freedom. This is also true of the Native strategists I've worked with. They don't just ask, what does religious freedom mean? They ask, what can religious freedom mean? The book follows Native claims to sacred lands, ancestral remains, traditional practices like whaling, religious practices in prison, and sacred objects in museum through and beyond the First Amendment, and take stock of what happens to those claims when they're made in the different legal registers they find themselves in. Even as the book follows the case law beyond the First Amendment or its statutory counterpart, the Religious Freedom Restoration Act, I contend that religion and religious freedom should remain in the mix. And though the book at times is deep in the weeds of law and regulations, the main story of the book is the story of resourceful, savvy Native peoples doing whatever it takes on behalf of their lands and their relatives. Suzanne Harjo impressed on me, for example, that the efforts she helped lead on religious and cultural freedoms all began at a sacred place. At Bear Butte specifically in 1967, when Cheyenne spiritual leaders put out the call for an encampment and meeting after their traditional summer ceremonies to identify injustices to sacred places and ancestors and to strategize how to address them. Quote, "We consecrated the coalition's strategic work on sacred ground," Harjo says. So, quote, "It was as good as done, and it was left to those of us who were young and strong to carry it out, and we are not finished yet," end quote. I haven't time here to summarize all the book's moves. Each of 8 chapters could have been its own book project, quite frankly. but I'll focus here on 3 of my key findings. The first finding is an inversion of the traditional, the recent phrase, "I'm spiritual, not religious," and can be summed up along the lines of religious, not spiritual. The first Native American appeals to religious freedom law came during the reign of the Civilization Regulations, a body of administrative law which between 1883 and 1934 criminalized ceremonial practices of Native peoples like the sun dance, the potlatch, and traditional healing practices. If the category of religion was being weaponized against them under what came to be called the Religious Crimes Code, Native people began to draw on the language of religious freedom to push back. Increasing numbers of Native people drawn to the intertribal peyote movement began in the 1910s, for example, to incorporate as members of the Native American Church, seeking legibility and religious freedom protections for their sacred plant and its sacramental ingestion. So too did Pueblo leaders in the 1920s seek to exempt their seasonal ceremonial dances from prosecution under the Civilization Regulations. In their effort to be legible to potential allies, these Native peoples appealed to an emerging romance with Native American spirituality. Indeed, my research shows that non-Native tendencies to misrecognize Native claims to religious obligation as mere claims to subjective spirituality can undermine Native appeals to religious freedom in the courts. To illustrate, I contrast the fortunes of Native inmates seeking religious accommodations in prisons, who can be said to succeed in court, relatively speaking, with the consistent losses in the courts of tribal claims to sacred lands. I argue that both are animated by the recognition of Native religion as Native spirituality. If it rolls off the tongue naturally, Native American spirituality is anything but a natural category, or preferable, I argue, to religion. It becomes a term of art adopted by the authoritative Federal Corrections Chaplaincy Manual to encompass the range of practices engaged by Native religionists of many stripes, including non-Native religious practitioners of Native religions. Rights to possess ceremonial tobacco, to hold pipes and other accoutrements of prayer, to wear their hair in pious fashion, or have access to sweat lodges. Don't get me wrong, Native inmates face huge obstacles to such rights on the ground, where wardens, wide latitude, and strapped chaplaincy budgets carry the day. But when cases have come to court, judges have with some frequency backed inmates' accommodation requests. By contrast, when Native nations, not just individuals, assert religious freedom rights to sacred lands, courts consistently reject them, predisposed to viewing claims to collective obligation in terms of subjective individual piety. But here, the interior piety knows no bounds. Even when narrow claims are made to particular places, this misrecognition sees a Native spirituality that asserts all land is sacred. So judicial concern for a slippery slope sets in. Courts have insidiously drawn on the spiritual, not religious trope of imagined Native nature piety to reason that Native claimants to sacred lands have not shown a substantial burden on their religious exercise. Substantial burden being the threshold determination for other layers of free exercise of religion protections under the law. In 1988, the Supreme Court found in a decision, I'll call the Ling decision, that a planned logging road through a sacred district could do enormous harm to the sincere religious exercise of members of 3 of Northern California's Native peoples, would nonetheless fail to prohibit their religious exercise. Listen to the spiritual, not religious logic that Justice O'Connor relies on in the majority opinion. No matter how much we might wish the government to conform its conduct to our religious preferences, she writes, and take no action that decreases our spiritual fulfillment, no government could function were it required to do so. Even though the Ling decision foreclosed sacred land protections under the First Amendment, its logic has undermined efforts thus far to find a sacred land protection even under the 1993 Religious Freedom Restoration Act, now the cutting edge of free exercise law. though other interpretations of the substantial burden analysis in RFRA obtain in lower courts in other circuits, the Ninth Circuit Court of Appeals looked to the Ling case to deny a religious freedom claim under RFRA involving an Arizona sacred mountain. The case is so compelling that I spent a lot of time in the book on it, and I think every American should know about this case. The Navajo, Hopi, and 4 other tribal governments asserted a RFRA challenge to Forest Service approval of a ski areas scheme to make artificial snow from treated sewage effluent on the San Francisco Peaks, a breathtakingly beautiful Arizona mountain where Hopi people say they go after death to become ancestral spirits and return as life-giving rain to the Hopi mesas. For the Navajo, or Dene, the Massif is the westernmost of the 4 sacred mountains that define their territory. An object of daily Navajo prayer, and so important to the culture that obligations of respect are even elaborated in Title I of the Navajo Tribal Code. And you can see that text on the slide in front of you. But where specific obligations and duties to ancestors, to spirits, and to land were claimed by Native peoples, the Ninth Circuit could only see the boundless, shapeless claims to nature spirituality of individuals. Listen to the tone of the decision in the paragraph in front of you. That is, the presence of the artificial snow on the peaks is offensive to the plaintiffs' feelings about their religion and will decrease the spiritual fulfillment plaintiffs get from practicing their religion on the mountain. Nevertheless, a government action that decreases the spirituality, the fervor of the satisfaction with which a believer practices his religion, is not what Congress labeled a substantial burden, a term of art chosen by Congress to be defined by reference to Supreme Court precedent on the free exercise of religion. The Hobby Lobby, by the way, decision of 2014, I argue in the book, completely reverses the logic of this decision. But in the interest of time, I'll move on to my next key finding, which is the disappointments of protecting religion as a cultural resource. Especially since courts have yet to find a religious freedom right to sacred lands, Native peoples have engaged and taken steps to transform the protections of environmental and historic preservation law. The most trying research I did for this book was in the weeds of these arcane review processes protecting cultural resources under NEPA and NHPA, the 2 main statutes, where inside baseball acronyms like MEFASAQUI and fly around the room like a Fonzie. And you can see what these acronyms refer to. MEFASAQUI is a major federal action significantly affecting the quality of the human environment. In the ideal, the procedural protections of cultural resource law are remarkably promising, creating conditions for consultation with the stakeholders and promoting mutual problem solving and agreement. In theory, though, Native nations can take their rightful place at the table and weigh in on the development projects that will impact them. And they can do so without having to make public the details of their traditional claims to sacred places and practices, which is a big deal for many people, Native people, whose sacred knowledge is also considered secret or initiatory in nature. And they do all this without having to translate their claims into the confining language of religion, with its frequent all or nothing logic of the dichotomy between the sacred and the profane. In actuality, though, these cultural resource laws and environmental laws just haven't delivered on this promise, as the Standing Rock case shows so clearly. NEPA and NHPA lack sufficient legal teeth beyond government being required to take a hard look before taking whatever decision it wants and can provide reasons for. Review processes have become the routinized purview of a class of professional consultants who are generally paid by project proponents like the Dakota Access Energy Partners. Government obligations to consult with the tribes have few enforceable standards, and there are plenty of tools at hand to, quote, streamline the process. The buzzword that I found was used by the particular consultant that Dakota Access had hired in their promotional materials. A way streamlining the process basically means using the tools to circumvent the fuller review that the statutes call for. What's more, the discourse of resource, whether it's natural resource or cultural resource, can flatten Native claims to the sacred into matters of instrumental value or into what can more easily be quantified. Take, for example, the Navajo and Hopi Sacred Mountain, not just a site, but a living presence in its own right. In their court battle, those nations brought religious freedom claims after NEPA and NHPA had failed them. Remember, the government agency authorizing the snowmaking scheme in the first place was legally obligated only to take tribal concerns into account, and they didn't. Or they took them into account, but it didn't change their minds. Scientists had found few archaeological sites or other physical evidence pointing to the urgency of religious practices on the mountain, and objective measures of the parts per million of pollutants in the snow made quick work of tribal concerns as though they were merely subjective in nature. So protecting sacred places as cultural resources may seem, at first glance, more expansive, but the indeterminacies of culture prove no less vexing than the indeterminacies of religion. And for better or for worse, it's religion, not culture, that makes it in our Bill of Rights. So far, the findings I've described have been consistent downers, right? The second half of the book is a bit more upbeat. It develops in stages my third main finding, which is that Native American religious freedom is perhaps best framed as a collective matter, a dimension of peoplehood. Here I follow closely the history of Suzanne Harjo and other strategic Native leaders who may have encountered closed doors to constitutional religious freedom in the courts, but who persevered and went on to Congress and drew on the no less rhetorically powerful language of religion to get remarkable statutes enacted. In 1978, President Carter signed the American Indian Religious Freedom Act, which is both over and underestimated at this point. Overestimated in that even as it provides a robust acknowledgement that U.S. policies had long had the effect of prohibiting Native religions, the Supreme Court in Ling found that it had no real legal teeth, that it was in effect a failed effort to make room within religious freedom law for distinctive Native traditions. My reading instead is that AIRFA, American Indian Religious Freedom Act, marks Native people's effort to encode protections for religion and culture into the growing body of federal Indian law that was then elaborating the unique nation-to-nation relationship between the U.S. and the federally recognized tribes, a special relationship that the courts were finding withstood the challenges of equal protection and the Establishment Clause under the Religious Freedom Clauses of the First Amendment. The Supreme Court said, for example, that the Bureau of Indian Affairs' hiring preference for members of recognized tribes was not racially based discrimination, but based instead on the legal status of members of tribes with which the U.S. has special trust obligations. A similar collectivist logic applied when this Native coalition secured passage of the Native American Graves Protection and Repatriation Act, which dramatically rewrote the rules surrounding display and digging of human remains, burial items, sacred objects, and items of cultural patrimony, that is, collectively owned and thus never alienable property. A discourse of the sacred permeates the whole legal process of NAGPRA, but the logic is a collective, not individual one. And when the religious right and left joined forces to get Congress to pass RFRA, Religious Freedom Restoration Act, in 1993, in order to reverse the Supreme Court's contraction of religious free exercise protection in its Employment Division v. Smith case, a Native religion case, I might add, they agreed not to seek a provision specifically remedying the result in that Employment Division v. Smith case, a result that criminalized overnight the religious practices of 250,000 peyote practitioners, members of the Native American Church, which that decision had affected. So instead of advocating for an amendment to RFRA, which would have required the religious left and religious rights kind of buy-in, Native strategists chose what they called a Scalia-proof angle instead, getting President Clinton and Congress to support amending AIRFA, the specifically American Indian Religious Freedom Act, with a toothy provision protecting the peyote rights and conforming that provision to the legal and political status of members of federally recognized tribes. If these efforts amounted to an enlargement of federal Indian law and its nation-to-nation structure, as well as its doctrine of the federal trust responsibility to include religious and cultural protections, my research has uncovered that courts, too, have found their way to recognize collective rights to native religions in terms of federal Indian law. The courts, too, not just Congress, but the courts. An accommodation under the Eagle Protection Act had, since 1962, exempted native ceremonial use of eagle feathers through a federal permit and distribution scheme. The restrictive permit scheme generated a remarkable number of religious freedom challenges. What most catches my eye is not, aside from the number of challenges, is the challenges that are brought by individual practitioners of native religions, some of them white, but especially those Native American practitioners who did not qualify for the accommodation because they were not members of federally recognized tribes. To make a long story short, 4 different circuits have agreed that the Eagle Act accommodation restrictions to federal recognized tribes does not violate the religious free exercise rights of individuals because they are ultimately outweighed by the compelling government interest of the federal government's responsibility to preserve and protect the religions and cultures of the tribes as collectives. The court's key move in one of the cases was its choice of one of 2 alternatives for interpreting the government's interest with regard to protecting Native American religion that was queued up by a series of previous rulings. A 2011 decision paid close attention to the language of the 1962 Eagle Act itself, which was for the religious purposes of Indian tribes, when it could have read for the purposes of Native American religion. Such wording would have been a clear indication, the 10th Circuit reasoned, that Congress saw itself protecting and promoting Native American religion per se, rather than expressed in the religion of federally recognized tribal members. But Congress specifically chose to tie the exception to Indian tribes rather than individual practitioners. From this, we infer that Congress saw the statutory exception not as protecting Native American religion, qua religion, which would be furthered if the scheme were extended to more practitioners. More religion is good religion, right? If we're talking about religion. Instead, they noted that the statute had conformed these protections to the tribes, and so the affirmation here of the federal responsibility to preserve and protect the collective rights of tribes to their religions, languages, and cultures trumps the individual religious free exercise rights of individuals. Now, you might rightly conclude that from this example that the utter indeterminacy of religion prevents any meaningful, consistent legal theory here about religious freedom. In order to have religious freedom, as Winifred Fowler Sullivan has it, you must first have religion. That may be, but here we have an instance of what religion can mean when keyed to the collective logic of federal Indian law. My final 2 chapters follow more forthright Native arguments toward collective rights to religion as peoplehood. The penultimate chapter concerns protection of traditional practices of fishing, whaling, hunting, and gathering in the Pacific Northwest and Great Lakes, where Native signatories to treaties from the 1830s to the 1850s reserved rights to continue their traditional practices off reservation lands. This is a big deal for us in Minnesota, where the Supreme Court has upheld the rights of the Mille Lacs Band under the Treaty of 1837, and there's other efforts in this regard. U.S. courts since the 70s have been keen to robustly interpret these treaty provisions, even under this current Supreme Court, with Justice Gorsuch now giving a strong vote, has affirmed this line of treaty jurisprudence. The state of Washington's salmon fishing peoples have won court recognition to 50% of the harvestable salmon as a result of all this, and crucially so. My book insists that this is not simply an economic or a political matter, these treaty rights cases, though they are those as well. They are also matters of deep cultural and religious importance. Frank Edwagishik describes how Michigan's Odawa Treaty signatories, he's from the first tribal chair of the Little Traverse Band of Odawa in Michigan, has said memorably, is my favorite quote in the whole book, that when his forebears signed the treaty and reserved rights to fish, he says, "Our ancestors didn't say, 'Those are our fish.' Rather, they reserved the right to fish. That meant they reserved a right to sing to the fish, to dance for the fish, to pray for the fish, to catch and eat the fish, but to live with the fish, to have a relationship with the fish." Where treaties include rights to such practices, the tribal sovereignty recognized within federal Indian law has proved a potent tool for Native peoples as they advance practices that are of religious and cultural importance to them. Still, federal Indian law has been at best a mixed bag for Native empowerment and remains rooted in such colonial contradictions as the doctrine of Christian discovery and the legal framework of, quote, quasi-sovereignty. That's why my final chapter looks to the enormous promise of the emerging norms within international human rights law for Indigenous rights. In 2007, the UN General Assembly adopted the Declaration on the Rights of Indigenous Peoples. It's a non-binding document lacking the actionable status of treaties and conventions, and the declaration avowedly creates no new human rights. Still, it's game-changing for declaring that all existing human rights, if they are meaningfully to apply to the world's indigenous peoples, must be applied as collective and not just individual rights. That's from Article 1. The book elaborates on the ways that the Declaration's norms might ripen to become customary law or to be implemented in domestic law and policy here in the United States and elsewhere. But what I find so encouraging is that the Declaration emerged from a distinctly indigenous conversation, one that recasts Western categories that otherwise divorce the sacred and the secular. While straightforward religious rights language can be found in Article 12, the Declaration is literally shot through with concerns for the sacred. The terms religious or spiritual modify enumerated rights in another 9 of the 46 articles. Article 25, for example, is a key provision on land rights, but it identifies indigenous rights to maintain and strengthen a spiritual relationship with traditional lands and waters. And the Declaration insists that self-determination must involve a standard of free, prior, and informed consent that states and corporations must observe on actions that affect Native peoples. If American laws and policies requiring consultation with tribes were operationalized in terms of this standard of consent in the UN Declaration, they could become stronger measures for protecting religion as a part of peoplehood. The book concludes with a look to successful negotiated agreements that grab no headlines because they avoid the courts altogether. Since the quiet goal for most Native peoples is to protect what's sacred to them without calling attention to themselves, the best outcomes, maybe, for Native American religious freedom are so far beyond the First Amendment, they remain entirely offline, and so it's fitting, perhaps, to end there. In Q&A, we could perhaps take up the timely example of Bears Ears, rightly called the first Native American national monument, on which we soon await a federal court ruling on the legality of President Trump's evisceration of the land base of Bears Ears by 85%. But let me close here with 2 lessons learned from Suzanne Harjo in the work for the book. They sum up the book's analysis, I think, quite well. First, if the Native maxim, "we have no word for religion," is compelling for stating the problem of Native American traditions in the category of religion, it's also true that it has played into a sense of the inevitable illegibility of Native traditions in religious freedom law. More insidiously, perhaps, is how the expression "no word for religion" suggests a slippery slope that comes with any native sacred claim, a deep-seated fear that because everything is sacred, nothing in particular can be protected under that moniker. Suzanne Harjo puts the matter differently. It's slightly different, but it's to great effect. It's not that Native peoples have no word for religion, she says. It's that they have no one word for religion. This is to say, indigenous peoples have religion, to be sure, but the ways they have religion are far more sophisticated, far more complex than what conventional wisdom expects of the term, much less what we expect of Native spirituality. Put another way, what might be understood capaciously as religion informs Native lifeways in multiple registers, their economies, their polities, their law, and their ways of inhabiting lands and waters. Second, Harjo has described religious and cultural freedoms as anything but peripheral to the political and economic concerns that often rise to the top of an Indian country agenda, which is understandable, right? Because of different ways in which those communities are disproportionately impoverished, and our own COVID moment has revealed those disparities in our own time. So it's understandable that much of the agenda would be about political and economic gains. But for Harjo, the religious and the cultural freedoms are crucial. Listen to her words here. Religion and cultural freedoms, she says, are atmospheric of other aspects of self-determination because they're crucial to the recognition of Native sovereignty. If in 100 years, she says, you have a situation where there's no tribal language, no tribal religion, where everybody has stopped dancing and stopped doing anything that relates to that tribe, then how do you think that tribe is going to be recognized for any special relationship or anything that we enjoy because of a special relationship? That'd be about a day and a half. With those words, I'd like to stop and say thank you again for your time, and I look forward to an exchange with some questions. Thank you.
Thank you very much. We'll now turn to questions from our participants, and thank you very much. I'm going to begin with this question for you. Does the current Supreme Court vacancy impact the future of Native religious legal freedoms? Big, broad question to start us off.
It is a big question, and certainly one that's on our minds today as we mourn Justice Ginsburg's passing on the day of her services. First of all, I just want to acknowledge just how monumental that loss is. I'm not a law scholar primarily, or a student of the Supreme Court broadly beyond the concerns that I have here, but that's it's just a tremendously important moment for where things go. That said, one of the things that I don't know if it's a silver lining from my point of view, but one of the things that we've learned is that President Trump's first appointment, Neil Gorsuch, who came from the 10th Circuit, and remember that was the other contested one, right? That Mitch McConnell said that Obama's pick of Merrick Garland wasn't going to go forward, and it got to go to Trump, and then Trump gets elected, and he appoints Neil Gorsuch. Neil Gorsuch was the author of the McGirt opinion earlier this summer, which was a tremendous boost to the status of treaties. And folks that I know in the world of federal Indian law hasten to point out that it's because he came from the 10th Circuit, which is the intermontane states in the West, where a lot of federal Indian law actually comes before the courts, relatively speaking. On that point, Justice Ginsburg had been a kind of mixed bag on Indian law kinds of questions. She'd sort of accelerated and had sided with tribes more in the last 10 years, but she's known for writing some decisions that not only went against tribes and treaty rights, but in a case called Oneida v. City of Sherrill, which for Native people was a real blow to treaty rights. So I'm not sure how to respond to that question. It's such a momentous moment for the court. I don't need to tell any of you that. How it's momentous for the concerns of federal Indian law is a bit more of an open question than I think you might think at first. And the same could, I suppose, be true for religious freedom law, but wow, to think just in terms of this bandwidth that I have is feels inappropriate. So let's just hope this process plays out in a fair way.
Yeah, boy, it is hard to say what will happen around this, considering Gorsuch. Totally agree with you on that. Although it might be that because they more strictly read statutes and also would be treaties, maybe a conservative would be helpful in this area, although maybe not so much in some other areas. We have a number of questions, so I don't want to say anything more other than to ask you, should Native American religious rights override FDA classification of substances during ceremonies?
Well, there is under the American Indian Religious Freedom Act's Peyote Amendment of 1994 a very specific example of how that should go down and goes down. So I'll just kind of call attention to that that particular point. It's also true, as I learned in the research for this book, that that particular issue tends to infatuate a lot of non-Native practitioners of Native religions. So one of those Eagle Act accommodation lawsuits that was challenging the protections for members of federally recognized tribes was rather odiously raised by somebody that I was in Harvard Divinity School with a long time ago. And he's a white guy, and he created his own tribe kind of in paper, and he was the leader of that tribe. And he made it all the way to a circuit court with this argument that the the accommodations under the Eagle Act were violating the Establishment Clause of the First Amendment because it had a denominational preference for Native American tribes, recognized tribes, over his Native American tribe. So I'm not necessarily directly answering that question, but I think I'm placing it in an important context.
Yeah, absolutely. I wasn't aware of that. Thank you very much. I would like to say, however, that the peyote, allowing peyote has helped other groups, like in the Gonzalez Viocentra case, where ayahuasca was permitted to practitioners there, and the peyote issue was definitely cited in that. What advice do you have for law students, us law students, it says, if we're interested in pursuing professional work in the area of assisting Native communities to defend their religious practices and lands?
That's a great question. Go out of your way to learn. I know that not every state bar exam and certainly not every law school makes a priority of federal Indian law. And for folks going into, say, family law or other areas of law, that can kind of be they can have their comeuppance of not being prepared with the sort of federal Indian law special relationship rooted in the treaties and in the federal trust responsibilities. So seek out the courses that are possible. That would be my first guess, or my first recommendation. And read imaginatively, read capaciously. My one-time spiritual director and mentor in this process, James Boyd White, formerly of the University of Michigan Law School, or emeritus, charged me, and I think it's a useful charge for any law student, is to sort of learn the language of law, but learn like a poet, not just to do what the language tells you to do, but do something with the language that it already hasn't done to pursue justice. And I know a lot of law students do read James Boyd White's work, but I commend his work to you to sort of open those doors.
That was profound, what you just said. I would that really having been a lawyer myself and then getting a PhD, I can just say that when I moved from the narrow confines of legal thinking into much broader ways of thinking about things, it was like I was schizophrenic for a while. I highly recommend always knowing that you are stuck in a whole system, way of thinking, language, etc. And if you're going to be unbiased, you've got to move out of it. And the way you said it was better. I would like to add, read your book. That will help the law students get a grounding too. Here's the next question. How have legal arguments for the protection of sacred sites been complemented, complicated, or compromised by protests and other non-legal social movement activities?
Great question.
Yeah.
So my book hews pretty close to the law, but in some ways that comes at the expense of the real story that I wanted to speak about, because the people moving the needle of the law are the people on the ground, and whether it's at Standing Rock, or the protests of Line 3 in northern Minnesota right now, or on Mauna Kea, an amazing movement that's happening on Mauna Kea. There is an assertion, don't get me started. There's other work by a colleague of mine named Greg Johnson, and there's a great book about the Dakota Access encampments that shows the power that can be claimed when people imagine their protest as ceremony. And I only spent a couple days at Standing Rock, and it was amazing to me. I start the book this way. I sort of felt like from Minneapolis, I was going out there onto the plains, and when I left there, I felt like I was leaving a center. Those people had created out of their from marginalized positions, claimed very powerfully their rights, and that's potent, and that's what moves the needle, and maybe that's the story that I also encourage you to read. So there's some great materials on YouTube and on the web about Mauna Kea and about the Standing Rock encampments and Line 3 and other movements.
You seem like a strong advocate and scholar of Indigenous rights, which requires a great deal of cultural humility. How would you describe your approach, and how have you grown in that area throughout your career?
Thank you. Anyone who writes a book knows that the more they know about their subject, the more they know they don't know. And it's my hope that this book starts a conversation. What I don't think I've delivered on, my late Ojibwe teacher, Larry Cloud Morganabon, challenged me once to say goodbye to a word that people won't understand. Take a big, complicated word and say goodbye to it every day. Try to be speak your mind, but humble yourself. Don't arrogate to yourself the sound of the Ph.D., the sound of that language. And anybody who's read parts of this book know, or just listened to me for a while, know that I haven't delivered very well on that. So I'm still at work.
I think you have. I think you have. I want to go back to a question that I thought might be good at the end here, although that one I think maybe was one. This question's about defining religion at all. Are there any useful models for defining it at all? And I would just like to say that the Native American push on expanding this in the prisons is actually having an impact elsewhere, because most religions around the world don't define themselves in the narrow way that the West has defined it, although the courts don't define it. What do you think is happening in the evolution of the way the courts are thinking about what religion means?
Well, I invite you to kind of jump in, Barbara, if you want to add to this. But just everybody should be on notice that it's a principle, you might say, of religious freedom law that the courts don't explicitly define religion, because that would excessively entangle courts as agents of government in making determinations about what counts as religion and what doesn't. And yet a book like this shows that it doesn't take a rocket scientist to know that there's implicit definitions, there's implicit determinations of which things are going to count as religion and which things aren't. And this gets played out in all kinds of different respects. So looking for, the court's definition of religion is a tricky kind of chimera. It's always about what's implicitly the case and never typically explicitly. That said, I commend a book called The Impossibility of Religious Freedom, which flashed across the screen by Winifred Fowler-Sullivan, which I think does as good a job as any of kind of showing how that process of trying to define religion in the law actually works. And if the question is bigger than that, like how do you define religion? Wow, that is like asking an anthropologist, how do you define culture? Or an economist, how do you define value? You explode the definition in the response.
Well,
kind
you
of
invited me
to that question.
No, you invited me to add something, and I'm just going to say what you said. Because you're absolutely right. They're dancing around the term sincerely held belief. But I don't know where that gets us. And it's going to be interesting to see what happens going forward, especially as Native Americans, as you said, are looking at it in terms of a collective idea rather than one's own belief, for example. I would like to invite you to say any last words in the 1 minute we have left about what your next project is.
My next project is an effort to do something like this book that's geared toward an even broader audience as a way of introducing Native traditions.
Wonderful, wonderful. Thank you so much. I am blown away by the work that you've done on this volume, and we're really lucky. Really lucky to have you today. Thank you, and thank you, Hans, for allowing me to be a part of it.
Thank you, everyone. Have a great day. Glad you could make it. Thank you, Michael. Thank you, Barbara.